All right, let's go ahead and call to order the first House Judiciary Committee meeting upon our return. And we do have one bill on the agenda today. This will be the first time we are conducting a meeting via Zoom. And we do have, by my count, about three House members that are here via Zoom. Nix, Holcomb, and Lewinsky. There we go. So we will begin as we always do with prayer, and then we will begin to learn how to conduct a meeting with some folks here and some folks not. So y'all bow your heads with me. Lord, we thank you for this opportunity to once again to gather as this committee. Lord, we ask you to bless us now and give us the wisdom to know how to move forward and do what is best for the people of this state. Lord, we know that we are in a nation now with many issues. We know that you are the great healer for all those things that ail us. We ask you to do that for us now and be with us as we move forward. Amen. All righty. Senator Ligon, welcome. Good to see you today. I may stop you here or there when something's not working with our new attempt to have some members join us by Zoom. But short of that, I want us to go ahead and allow you to present Senate Bill 442. And then I know that we have about 4 people that have signed up to testify on the bill as we move through. And after your testimony, then we'll allow them to come in. I think today, since we do have some open seats in the back because all the committee members aren't here, I will allow you to sit at one of those where you can still be in the room and hear what they say, if that's okay with you.
That would be fine.
Okay. Senator Ligon, welcome, and tell us about Senate Bill 442.
Well, thank you, Mr. Chairman, and it is always an honor to be before this committee, and so we'll go ahead and get started. This bill, Senate Bill 442, is amending the OCJ 44-3226, which is part of the Georgia Homeowners Association Act. And let me begin first by stating that this act does not apply to every homeowners association that's created in the state. It specifically provides that in order for the provisions to apply to your association, that the covenants have to provide an affirmative statement that the association will be subject to the act. So it's not going to capture every situation. The issue that we're trying to solve is this. Since the recession, there have been more and more individuals families who are needing to lease properties, and there have been some investors who have bought homes in some of these subdivisions that elect to be subject to the act. And these are usually many times your higher end subdivisions. And then after that occurs, the association will come back in and they will amend the covenants to prohibit the leasing of the property. Well, a significant investment has already been made. It's providing an important service, and these are the long-term rentals where you're looking at 6 months, a year or more. This is not intended to address the VRB by owners, these short-term rentals. And what the language of the bill does, it allows those homes that have been rented or used this way to continue doing so. And the operative part of the bill is on lines 26 through 28. And it says, no amendment shall be made so as to prohibit or restrict a non-owner occupied lot from continuing to be leased or rented from the pre-amended instrument. And you notice that it uses the word continuing to be leased. So once the property is being used for that purpose, I would say that once it becomes occupied, owner occupied, then I guess the covenants could be amended to prohibit any further leasing, but it's not going to, it's kind of like grandfathering in those properties that are currently leasing the lot. That is the intention of what this is supposed to do. Now, we had a lot of hearings on this over in the Senate, And this language in the bill came about as a compromise between groups representing homeowners associations and the rental association.
All righty. Questions for the senator. Ms. Oliver, will you press your mic button? Let's see there. Number 5. Go ahead.
Mr. Ligon, I have 2 questions. You said in the beginning, your first sentence or 2 was, this doesn't apply to all HOAs. It only applies to some. And I didn't understand your qualifying
okay.
on who does this apply to?
Okay. We have, I call it the Georgia Homeowners Association Act or the Georgia Property Owners Association Act. I can't remember the exact name, but it's a code section that sets out certain regulations and benefits that can accrue to a homeowners association which elects to be subject to the act. So
Don't all of them elect to be subject to that?
no, they do not.
How do they make that distinguish? How does that break down?
Okay. You have to have an affirmative statement within the declaration that the association will be subject to the act. If you do not have that statement within the declaration, the act will not apply to your association.
And how would I I'm trying to figure out, how do I as a legislator know whether that's most, all, a few? I mean, does that relate to a specific case
Right.
law that's been decided on?
No, well, no, it's not. It's not case law. It's actually within the existing statute, and the statute says unless your association elects to be governed by this statute, it won't be. And I'm sure that there may be more associations around the Metro Atlanta area that are subject to the act. In my area, many of them do not elect to be subject to the act, and frankly, there are benefits by doing that, especially when you get into, I don't know how deep in the weeds you want me to get into telling you what the benefits are of doing that, because it's kind of off topic, but I'll be.
I'm just trying to figure out who it applies to. But may I ask one more question, Mr. Chairman? You say it doesn't intend to cover Airbnbs, but what in the language of lands 26 to 29 excludes the coverage of Airbnbs?
Well, there's no language that excludes that. I guess the language is basically worded so that the effect is to grandfather in.
So if I have an Airbnb, if I'm in an HOA and I've been using my house as an Airbnb, this would cover my Airbnb business.
It could, but I'm told that the groups that are asking for this, that they're in the long-term rental business.
Thank you, Mr. Chairman.
Ms. Silcox? Oh, Mr. Reeves, I'm sorry.
Thank you, Mr. Chairman. Thinking through my questions here. So I think you've answered this, but from a very elementary perspective, if a homeowners association has affirmatively elected to be subject to the Property Owners Association concept in Georgia law, which provides that then they are governed by a lot of statutory mechanisms that may be different than what an HOA covenants and bylaws that do not opt in, right?
Right.
So all neighborhoods who have opted in would be subject to the terms of your bill, right?
Correct.
Okay.
Correct.
So walk through me what that means. Kind of walk through what that means. Describe, I live in a neighborhood, and let's pretend, I don't know if my neighborhood is or isn't subject to the state law provisions, but I live in a big 300 house neighborhood. Kind of walk me through, if we are subject to this, walk me through exactly kind of what levers it pulls and what in putting it into practice, what it means.
If your association is subject to the act and this bill passes, then let's suppose that you have 3 homes in that development, that are currently being used as rentals. Families come in, or an executive has rented it for 3 years for his family. They're living there. And you decide, well, we don't want any more houses to be used as rental. We want to continue, we want to prohibit any further expansion of that. Then my opinion is that under this bill, you could have an amendment to the declaration that would prohibit any further conversion of properties from owner occupied to renter occupied. But that declaration would have to allow those that are already being used as rentals to continue to be used as rentals. But if they're ever sold and the buyers come in and now they're owner occupying the home, they couldn't come in and then convert it back. Because the word continuing, the word that is used in the bill is the amendment cannot prohibit or restrict a non-owner occupied lot from continuing to be leased or rented. So once it becomes owner occupied, it would be a conversion back to a rental. It's not a continuation of something that would stop. So that's how it would work.
So if, let's just suppose there's a neighborhood in all of our districts that is being, that there are a lot of homes that are being sold and turned into rentals, and the neighborhood sees that is impacting the property values and declining and causing the property values to decline as a result of a large percentage of houses converting to rentals. Does that, then if the HOA was subject to the statutory act like we're talking about, then they would have the inability to modify their covenants in order to stop the transition that's happening where houses are being converted to rentals and thus property values are declining. Is that right?
No. It would prohibit the further conversion of owner-occupied properties into rental properties, but it would permit those that are already being used as rental properties to continue to be used as rental properties, because those individuals or persons have made significant investments in those properties. And if let's say you prohibited them from renting them out again, then that can be a pretty significant economic loss to them. So
this essentially protects a real estate investor who buys houses in neighborhoods and rents them out, and it gives some assurance to that investment. It doesn't. So let's say you're in a neighborhood of 100 houses and 10 houses have become rentals. It doesn't prevent the HOA from saying, we're not going to allow any more houses in this neighborhood. We're going to change our covenant so that no more houses in this neighborhood become rentals. But what it does do is it says those 10 that already are, they have to continue to be, so long as they're continuously, it's a continuing rent or lease, as opposed to if it's sold and then the owner occupies it, right?
Correct. So if it's leased, this bill passes, then let's say the rental company decides, we want to move this investment, we want to buy a different property in another area of the country. They sell this property, the new owner comes in, it's owner occupied, they move their family in, they live in it, and they're not renting it out. Once that happens, then that property cannot be converted back to a rental once this bill passes. So.
Ms. Silcox?
Thank you, Mr. Chairman. Senator, I appreciate you bringing this bill, but my concern is, would you agree that people who own their property take better care of it than those that rent it?
Well, yes, that is true, but they're also, if you absolutely destroy it, then you can have some liability as well.
Sure,
So,
sure. But in
but
general,
in general, most
general.
people that own their properties take better care of it, but
in general,
some people don't.
in general, if you pay homeowners dues to protect your neighborhood, don't you think that, don't you think that's a good thing? Don't you think it keeps property values up? And
Oh, absolutely. I think that there's a tremendous benefit to values to having homeowners associations. And, you know, I do think that this bill is trying to strike a balance between the interest of the owners of properties who live there and those that have made a significant investment in properties and are renting them out. And the balance is struck by basically creating a grandfather provision so that you could stop any further conversion of properties to rental properties, but you allow those properties who are now rental properties to continue their operations, and then at whatever point they stop being rental properties, then they would not be converted back.
so is it true, do you think, that a homeowners association could agree to this without this law?
Well, they could, but the practical, the real life effect was that they were not agreeing to this. And so you had situations where properties were being rented out, and all of a sudden the owners are being told, well, you can't rent this out anymore. And so what do you do then? I mean, you have to put your property on the market, or it sits there vacant. And the truth is that vacant properties are not an asset to an association either. They maybe their condition can get worse. And then if you have 3 or 4 properties in a development that all of a sudden go on the market, maybe you flood the market. I mean, so there are lots of different angles and ways
Right.
to look at this, but
Don't you think it's good, though, for homeowners associations to have the freedom to decide whether they want to do this or not?
No, I agree that there is a freedom to do that, but there's also you might want to say a vested property right for people who make substantial investments with the expectation that they're going to be able to rent that house. And then what happens if they're in the middle of a long-term lease and all of a sudden they're told, well, you can't rent that anymore? Well, you've put them in a position of either of maybe getting sued because the association is now bringing some sort of action to force them to vacate the property. So how do you handle that?
What about a sublease? If you have, we had recently a fellow that he had leased the property in a homeowners association, but then he subleased it out for folks to throw these parties, and it turned into a party house, became a real big problem.
Well, I mean, that could, I mean, in those situations, it would seem to me that if your covenants provide that homes are to be used for residential purposes, throwing parties and having dinners may not be consistent with those protections, or it certainly may even violate zoning provisions if you have a more of a commercial type situation. Whereas with rentals, the use of the property is consistent with the home ownership as a resident. So
Thank you.
Next, we'll try to take a question from one of our persons participating by Zoom, one of our members, Representative Walensky.
Thank
Media
you, Chair.
Services, would you please open his mic?
Can you hear me?
Mike, is your mic working?
I'm unmuted. Testing. 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 Can you hear me? Hello? Do you want me to text you the question? I can call you. I heard that.
All right, let me make sure that Media Services realize that I have asked them to
You want to put me on speakerphone?
Dominoes.
You want to put me on speaker?
Yeah, I'll put you on speakerphone since we can't get that to work. Oh, try it now.
All right, testing. Testing. Sure, can you hear me? You put him, I'm unmuted. I am unmuted. Do you want to put me on speakerphone? Okay. Can you hear me? Testing. Yes? Y'all
Now
can
we
hear me?
have your mic. Go ahead.
All right, thank you all. Let me move my phone. Oh, now I'm thank you, Senator. My question is, under this bill as it currently stands, if somebody's renting out their house, I understand that this bill would not prohibit the HOA from stopping them if they create that law, they would get grandfathered in. But is there anything in this bill upon the sale of that, after somebody owns it, the HOA makes a law, and that person sells their house? Is there anything in this bill that stops that grandfathering and not going on to the purchaser of that property?
Well, I mean, you'd have to look at the language that's used. It says to prohibit or restrict a non-owner occupied lot from continuing to be leased or rented pursuant to the pre-amendment instrument. Now, I mean, if it goes to an owner occupied purchaser, clearly that would stop that. Now, I assume you're asking what would happen if another investor were to buy the property to lease it out. Is that your question?
Correct. Yeah. I mean, based on my review, I don't. Looks like the bill does, and I would just request that we add in something that upon the sale, that stops the grandfathering, if that's not what the bill says at this time.
I don't think that the bill addresses that situation. The question is whether or not the sale would be a breach which could be considered a not continuing the leasing or rental of the property. So.
Representative Walensky, did you have more questions?
Yeah, that's all I have, Chair. Thank you.
Ms. Rich?
Hi, Senator Ligon. You had indicated that the purpose of this legislation is to regulate homes that are rented long-term, not Airbnb or short-term rentals.
Right.
But there's not anything in the language that would limit it to that, is there?
No.
Okay.
No, it does not say that. I can just tell you that the proponents of the bill, the issue arose out of a long-term rental situations.
Was there any discussion in the Senate Judiciary about limiting it to long-term rentals, long-term residential rentals, as opposed to just leaving it open like it is?
There may have been some, but there was not much, and this has been so long ago that frankly, I can't remember. I know that we purposely did not go into the short-term rental issue because there were a lot of other issues with that, which we're all aware of.
Mm-hmm.
We were just focusing on, this particular aspect of the bill. So.
And then Representative Walensky's question was really on point as to
Right.
the policy argument, the fairness. Of course,
Sure.
if somebody buys a property and there's no limitation on rentals, then it does seem unfair. But if the property is then sold to another investor, well, they're kind of already on notice.
Right.
So
That's
was
right.
there any discussion about limiting it to the?
No, actually, this was the first time that this point has come up, and I recognize that as a valid point, and it may be something that the committee wishes to consider, and then certainly there seems to be a fairness aspect to that as well as trying to help strike the balance a little bit better.
Okay. All right. Thank
So-
you.
Senator, on that point, I was here having my tutorial on Zoom and how these buttons work. So I did not have the chance to pay great attention to Representative Walensky's question. Flesh that out for me.
Well,
you're just
what
talking
he
about.
was wanting to know is if you had a property that's occupied, this bill passes, you had a property occupied by a renter, and then the company sells that property. Could they sell it to another investor who could in turn continue to rent it out, or would they have to, the sale have to go to an owner occupied person?
Okay.
I don't know that the bill actually would prohibit the sale to an investor. I'm not for sure if the sale would operate as a break in the continuing to be leased type language as to prohibit it. So,
All right. Whip Kelly, before I turn that mic on, we are told that the clips where those mics attach are coming in tomorrow. And for you to be very careful as you move it, and it's better to lean toward it than to try to adjust it. So having said that, don't break anything. So, Mr. Whip.
Well, I certainly appreciate the ingenuity you've shown, Mr. Chairman, by replacing the clips with a piece of blue tape. That showed genius on your part, befitting the chairmanship. So thank you for that. My question again will kind of go to this issue, and I know we're trying to strike a delicate balance here in terms of the owner of the property versus those whose property is impacted by the ownership of the property, and that's always a delicate balance we have here in the law. And I think what Chair Lady Rich brought up in terms of the short-term rental is something that I think could possibly may need to be examined, because I know that's a broader conversation we're having in terms of how to deal with short-term rentals. But when I work on closings for individuals, especially in homeowners associations that have deeds and covenants, it's always important for me to be able to relay to them what the current covenant is, because they're purchasing the property based on the rules that are in place when they purchase it.
Right.
And so for me, I think about when you're buying a piece of property, you're buying that bundle of rights. And if you're on notice that it's not available, that's one thing. But having something that you expect to be able to purchase as an investment and then to rent out later to have that taken away from you retroactively, that's essentially a taking. And if any government acted that way, there would have to be just compensation. And I don't think that we should allow that practice to continue. And another situation that I want us to think about in this committee is when we do talk about property values. I imagine a lot of these properties were purchased during the Great Recession.
that's right.
And we all know how devastating it was to see properties foreclosed in our communities. My community was certainly one that was impacted by that. We saw a lot of foreclosures. And the only people that were able to come in with capital at the time to purchase them were investors who provided two services. One, they made sure that the property then became occupied in somewhere, one way or the other, and they made improvements to the property, which helped, one, stop the bleeding, and two, it allowed for a way for individuals to get into homes again. And I think that's something that's very important. I mean, it's a realization across our state that not everyone can purchase their own home, and we need to have good quality rentals available to them. And that's why I would like to see us, address Chair Lady Rich's concern about the short-term rentals. But I think it's important that someone's bundle of rights, not be able to be taken away retroactively after they've purchased for that. And I'll be glad to help work on the short-term issue, but am supportive of the goal of this legislation moving forward.
Representative Jones? Wave. Chairman Welch?
A couple of proposed amendments for you to consider, language to consider that I think addresses not all, but most of the concerns that have been raised. Just to consider, Senator Ligon, after the word rented on line 27, a term of 6 months or longer. So between rented and pursuant. And then at the end of, after on line 28, after the word instrument, and then before the period, insert a semicolon that said, provided, however, that a sale of such lot shall be made to conform to the instrument as amended.
Read that last one again.
Yeah, on line 28, after the word instrument and between instrument and the period, insert semicolon, provided, however, comma, that a sale of such lot shall be made to conform to the instrument as amended.
Ms.
As amendment or
As
amended?
amended.
As amended.
Mr. Chairman,
Yes.
if I may suggest that, I mean, if we're going to do this, that you change the word instrument to the word declaration.
Okay.
Because I suspect that throughout the code, the word, you're always referring back to the declaration.
The reason why I use instrument is because that's the language that the senator's language proposes, pre-amended instrument. So I thought that was what we're talking about in terms of.
Yeah, that's right. And maybe we need to change that to the, we may need to look at the code to make sure that well, actually in the existing language, it uses the word instrument. I would have used the word declaration, but we can go with instrument then. If that's what they're using in the code.
Yeah, it's,
Okay.
I would have gone declaration. That's the way I talk about it too, but
Right.
code says instrument.
Representative Welch, hold those thoughts, and when we get to the point, we have 4 witnesses. When we get to that point, we'll certainly
Yes.
consider those
Okay.
amendments. Okay, any further questions? Also from our Zoom participants, no one has their hand raised, and okay. So what we will do now is, Mr. Wilson, did you have a question? All right, you are number 4, okay?
Number
Mr.
4.
Wilson?
Senator, my question is if you're familiar with the 2009 Georgia Court of Appeals case, Charter Club v. Walker, my reading of that case, which the Georgia Supreme Court denied cert on, so it's binding case law now. My reading of that case seems to be that it institutes what your intent is here, and thus this bill doesn't even seem to be necessary. Can you speak to that?
I'm not familiar with the case. I do know that it seems to be occurring, and that's why we're being asked to bring the bill. So,
Thank you.
Representative Wilson, can you highlight that for us? Can you talk more about it?
Well, I just read the bill or the case earlier today, but this issue came before the court, and the Court of Appeals said that their interpretation of the law as it is that an amendment cannot be made during the pendency of the instrument.
When was that case? Do you have
the case
date?
site?
Yeah, when was it? Recently or was it?
December 2009.
09. Okay. Well, I think we're going to have a lawyer in here in a second. As a proponent, that might be a good question
Sure.
To ask. Okay. So at this point, Senator, if you would like to, maybe there's a chair right behind you where you could sit. We have some open seats, so I'm going to allow you to stay because that might benefit everybody involved. And at this time, the chair would refer to those in the hall listening. I know some of you out there had asked to testify. If Elmer Stansel and Sam Olens would come in. Elmer Stansel and Sam Olens, if you would enter the committee room. Elmer, wait right there, you and Sam. So I know that you are two are together. Mr. Stansel, I know that you're represented by counsel today. We always encourage people to be represented by counsel. Yeah, so my purpose for bringing you both in is I'm going to allow one of you to stay because we have some empty seats while the other one testifies. Is who do you want to go first? Begin? Okay, Mr. Stansel, come on up to the center seat right here if you would. Mr. Owens, right there is fine. Mr. Owens, yeah. Have a seat right there, and you can hear each other. Welcome. Good to have you.
Thank you, Mr.
The
Chairman.
speaker has told us when we're speaking into the microphone, we can take our mask off, so you're welcome to do that if you like.
Okay, thank you.
And if you would introduce yourself to the committee, and we'd be happy to hear from you.
Thank you, Mr. Chairman and members of the committee. My name is Elmer Stansel. I'm with Denton's. We represent the National Rental Home Council, which is a national group made up of companies that exclusively or have portfolios of rental properties that are exclusively single-family homes. And they have a significant investment in Georgia. They have over 27, their member companies make up about 27,000 properties in Georgia. And these are, again, these are all single-family homes. We support this legislation and Senator Ligon's effort in this bill to allow companies and people that own property in homeowners association to continue to rent their property. It's been the experience of some of the companies within the membership of this organization that covenants are passed after they have purchased properties, invested a significant amount of money in those properties that restrict rentals in the homeowners associations that they're in. So this, would allow the families that are renting these homes not to have to leave if they don't choose to do so. And for these companies and the owners of these property and any owner of a property in a homeowner association that is renting a property to be able to continue to rent that property. Be glad to answer any questions, but that was, we support this legislation. And we were listening in the hall on some of the testimony that was given before, and I was writing furiously on the language that Representative Welch mentioned, but I'll be glad to answer.
And I
any
was going to have
questions.
those repeated for you and
Sure.
Mr. Owens in a second here. But I think what I will ask is that I know that some of the questions may go to what I would say facts, and some are legal questions that have arisen. I would offer to you, Mr. Owens, do you want to come up and speak, and then we'll allow members to say who they want to ask the question to? Because you may add something to the conversation that's already been had. Mr. Stansel, if you want to go back to the seat there where Mr. Owens was, and Mr. Attorney General, how are you doing? Come on up, and please introduce yourself. And as I mentioned to Mr. Stansel, the speaker has told us that if you are addressing in the microphone, you're welcome to take your mask off so we can be sure and hear you more clearly.
Thank you, Chairman.
Uh-huh.
It's a pleasure to be here. Appreciate the opportunity. Let me start by mentioning a comment that was stated earlier, and I apologize. We frankly had trouble originally getting the streaming, so we missed about 2/3 of the senator's comments. So if I repeat or don't repeat, I apologize.
They were riveting.
Okay, thank you.
Yeah, the 2/3 you missed, by the way.
Better for you to say that than me, sir.
That's right.
Prior recession, my age went through that same process. So as a result of 07, 08, you have a whole lot of folks that have really good jobs and good incomes that are more interested in
stop you.
Sure.
Mr. Owens, tap into your mic. We want to make sure it's working there.
I just probably need to be closer to it.
Well, no, actually what's
Oh.
going on is that we have, of course, a second operation of people listening here through Zoom. And we were, I think, told that maybe your mic wasn't working for them.
Okay.
So we're good now? Okay. I apologize
No,
for interrupting you.
thank you, Chairman.
Please continue.
So, you know, the HOA Act said you've got covenants for 20 years and then it was changed to make them permanent. Then in 94, we passed the POA Act, Property Owners Act. And the Property Owners Act said that by a 2/3 vote, you can affect every property owner, whether they individually agree or not. So it relates to this rental issue. You can have someone currently under Georgia law. They can already be renting. The association under the POA rules can have a 2/3 vote and you no longer can rent, even though you had that vested property right and it was taken away from you. Also, with regard to a question I think Representative Silcox asked earlier, let's face it, the homeowners aren't writing these covenants. Developers are writing these covenants, and these covenants come with the subdivision when you buy it. So if you create a POA, which is what most folks are now doing instead of the HOA, and you provide that 2/3 vote, that means that a lot of people with vested property rights are now subject to a vote at any time by that association to remove those rights, which I think is improper. So when you take the change in Georgia law on POAs and you take the fact that more and more folks, both my kids' age and my age, are interested in leasing than owning houses, what this change does is actually provide us more stable market versus an unstable market. Last comment in that regard, there was a reference, I think, to a case from 2009.
You want to restate that case, Mr. Wilson, so we can make sure we're talking about the same one. You're number 4. Go ahead.
It was Charter Club v. Walker, December 2009, Georgia Court of Appeals case.
Go ahead, Ms. Owens.
So I would refer you all to a 2018 case, Georgia Appreciation Properties Incorporated versus Enclave at Riverwalk Townhouse Association, 345 Georgia Appeals 413. And on page 420, it pretty much says you don't have the right to sue unless it's a derivative action. And to this date, everyone is still trying to figure out what the Court of Appeals meant when they used the term derivative action. So, and I'm not being flippant. So you can ask people on every side of the issue. So as a result of this 2018 case, it clearly gives associations the right to go in and stop current property owners from renting. So I think part of the discussion previously in the committee was, of course, grandfathering. But we have a current law on the books in Georgia that says, absent this book, there really is no grandfathering, which is why this bill is so important. And, you know, clearly I started my whole quasi-political career being president of East Cobb Civic Association. I get the value of a homeowners association. I also get the fact that I, as a property owner, have rights too. And that if there is a market through millennials and baby boomers for these homes, why shouldn't I be able to take advantage of that market? Now, clearly the homes need to be properly maintained, kept, et cetera. But without the grandfathering provision that is in 442, there is no protection under Georgia law based on the 2018 decision. And I think that's what's important, because what Senator Ligon's bill is frankly give people that option again that they no longer have due to that 2018 decision.
Okay.
Thank you.
Questions? Ms. Silcox, did you want to address your questions to Mr. Owens? Go ahead.
Thank you for coming, Mr. Owens. Always a pleasure to see you. Was curious how you would respond, and it's interesting because I have one of my best friends is in real estate and follows trends in real estate, and I agree with you that in the past decade the trend has been more towards rentals, but interestingly with COVID, things are going the other direction. People are actually buying out. They're starting to buy more out in the suburbs, and people want to spread out again and have ownership, have home ownership because of COVID. That's the current trend, is people actually want to spread out, own their own home, and be less close to people than previously because of COVID. I don't know that this would change this bill in any way, but my concern really is the problem we've had in Buckhead and Sandy Springs, and that is with people, and like I mentioned, in one particular house that's not very far from me, that someone had leased it and then they subleased it. And we keep seeing these party houses. And these party houses are really a problem because under the municipal code, the maximum fine is $1,000. And these guys, a lot of them are very successful musicians. And so this is pocket change for them. And so our hands are kind of tied. So, from my perspective, representing my district, this is, to me, tying the hands of the property owners to collectively bargain. We don't want rentals in our neighborhood anymore because we don't want these parties and disruption of our quality of life.
So I certainly, I'm not going to comment on COVID because candidly, I don't think we have any data to really work on that. I do recall that the cheaper the price of gas, the more people live out in the exurbs, and the more expensive the price of gas, the more you move in to save that money. As a general statement, there are nuisance actions. As a general statement, there are many ways in which community development departments can work through the zoning code. And of course, we're familiar with zoning codes.
Yes.
Frankly, some governments have the guts to aggressively follow their code, and some look the other direction. Some governments don't want to bring nuisance actions, and some do. If you have a property that has parties, if you have a property that's a disturbance, you can file a nuisance action under Georgia law, and it's frankly effective. But you have a lot of governments that candidly don't want that work.
That's fair.
But nuisance actions are available for any type of situation like that. And nothing in this bill protects someone who doesn't take proper care of the property, etc. I mean, I dealt with that when I was chair of Cobb a lot, and we put in the code how many cars could be in a driveway, that cars couldn't be on grass, that, noise levels at a certain time of day. So from a zoning perspective, you can frankly be active. And as a result of that, Cobb County at that point actually got very active. And the community, as you're stating, really appreciated it because they wanted the efforts to clean up the community.
Okay, now the chair is now going to try to go to a Zoom question with Representative Bruce. So Representative Bruce, get ready. Oh, he took his hand down. If you still want to ask your question, give me a thumbs up.
It was actually on
Bruce.
It was on.
Okay, he still wants to ask questions. So give me 1 second because I have to turn my mic off and everybody else's to turn yours on. So hold on just a minute.
I'm actually on. I'm actually on now. Okay. And it's really was on the same topic, and he may have answered this question, but we got cut off for a minute, so I don't know. We couldn't hear what he was saying. But the concern was people having, I guess the definition of rental is where I'm going with this is rental, about a month, by the evening, because some people just want to rent the house, for an event and stuff like that. So how are they defining rental?
Now.
And I think Senator Ligon commented in this area too. Senator, correct me if I'm wrong, that previously didn't come up. And there is no intent for this to be a short-term exercise.
And this may be a good time for Mr. Welch to tell us about his amendments that you probably were trying to listen to in the hall. Your number is number 7. Tell us about your 2 amendments because I think it addresses Representative Bruce's question and also what Mr. Owens is talking about now.
So the First Amendment was at line 27, and this was to address the duration of the rentals that could be continued. And it would say, between the words rented and pursuant, it would say we would insert a term of 6 months or longer. So at least or rented for a term of 6 months or longer pursuant to this. That would qualify the
That's fine,
duration.
Representative.
So that it
So
wouldn't be.
I think it takes us, Mr. Welch, out of this discussion of short-term rentals and it puts it into a long-term rental
Yeah,
issue.
that was never the intent.
Yes,
I
right.
understand the question and the concern.
So Representative Bruce, if you're listening, the definition of rentals is now going to become something that is longer than 6 months in this bill. Does that help you? Okay, he nods yes, okay. And then you want to go ahead and tell Mr. Owens your second amendment that you added on at the very end of line 28?
The Second Amendment was to ensure that it's not a prolonged, selling of the property as a rental property for future purchases. So that the vesting of rights typically in Georgia laws is that it's a personal right, not one that sticks with the property. At least that's according to the case law. So in that respect, at line 28, after the word instrument and before the period, insert semicolon, provided, however, that a sale of such lot shall be made to conform to the instrument as amended.
And I don't think that, correct me if I'm wrong, Senator, I don't think there's concern with that provision either. Yeah, that's not the intent. So we have no disagreement with either amendment.
Okay, thank you, Mr. Welch. All right, we have some more questions for you, Mr. Owens.
Can they be as easy as the prior?
Well, this guy's from Cobb County. He loves you already. So let's see what Mr. Reeves wants to ask.
I do love Mr. Owens, but okay, so I have a lot of thoughts swimming around in my head on this. I'm trying to think of this in terms of my district and the neighborhoods I represent. I have a lot of big neighborhoods in my district that have HOAs, and I have no idea. I don't even know if my own HOA is subject to the statutory act or not. I certainly have no idea what other neighborhoods are, but I do know that a lot of my district has neighborhoods that have experienced a decline in values and a lot of increase in rentals in those neighborhoods. That's one concern I have. And the second, and I know that you understand this, as you were aware, when we were talking earlier about the county, case in point, Kennesaw State University is in my district, and as you know, there has been a perpetual conflict between the neighborhoods surrounding KSU and the conversion of houses in those neighborhoods to fraternity, sorority houses. And I am very aware of exactly what you said about the county codes and even, the municipal codes and limiting and trying to create practical limitations there. And this isn't my fault or your fault, or nobody in this room can solve this, but despite all of these things, nothing seems to change and nothing seems to get better in these neighborhoods that are experiencing these issues. And if it's not what, and something that I have been dealing with, particularly in some of the neighborhoods that surround KSU, is the conversion of houses or being bought by investors and converted into sober man living houses that have no oversight. It's just a house where people are living together in a supposed sober community, and they are absolutely destroying some of the property values, and that parents don't want their children to go outside. And so I look at the issues going on in my district as it relates to things like this, and I understand the interests that we have here with the certainty of an investor's rights. But what happens, and I feel like there's a trend of spiraling out of control of what's happening when investors buy houses and how that's impacting neighborhoods. And so, and I guess I say all that to say that probably my biggest concern is that the local authority for local governments to actually intervene and do something meaningful doesn't seem to be effective, because it's just not happening. And I know that with the sober man living, it's a constitutional issue, because it's addiction recovery is covered under the Fair Housing Act because it's a disability, and we can't zone that, and so opening the door for more of this, or for opening the, well, not necessarily more of this, but in a way that solidifies those rights even clearer. While it may solve some problems, it potentially could create some more. So these are the things that I'm wrestling through as we look at all this.
So clearly the numerous facilities are subject to federal laws you referenced, Representative, and local zoning is superseded by the federal law. I would suggest to you that when I was chairman and we passed some zoning changes, there's a lot of good changes on the books, but you got to enforce them like a lot of other laws. And that's where I was frankly referencing that the government has that obligation to do that. I'm very familiar with I forget the name of that golf course.
Pine Tree.
Right.
Pine Tree and Weatherburn Woods. And,
absolutely. Absolutely. And I've known those folks for 25 years at least. Where at the Weatherburn, they used to go to the East Cobb Civic meetings, and I used to laugh because there was nothing East Cobb about it, but they wanted our assistance. And you literally have to have the folks in community development show up in those communities, show up at nights, knock on the door, see the number of folks that are unrelated. Back then, I want to say the number was 4, that you couldn't have more than 4 unrelated. I candidly don't know the current number under the Cobb County zoning code, but I would suggest to you, these are very doable things if your government will take the time to do it. It's straight compliance with the code. And I know from a KSU perspective, we used to always tell the neighborhoods, call the county. If there are students that are not properly behaving and they're ruining your neighborhood, you need to do what you need to do to protect your neighborhood. We weren't there to protect the students. We were there to protect that the neighborhood rules were followed. And candidly, I haven't heard a lot about this in the local newspaper about problems, but I would suggest there's recourse between the nuisance statute and between zoning, but you literally need to get the county or the city to do it.
Year after year, I go to the annual meeting there, and I hear the same thing every single year, and the same frustration and the same, stories about what has tried to be done. And I think that when you to put the onus on somebody to file a nuisance action, that's that's a very burdensome.
Government can do that.
Well, I understand what the options are in law, and I understand what it says, but the implementation of it and the way that it's playing out is, I don't, those aren't the problems aren't resolving, and I don't know if that's because of the approach or not. But so again, I don't have my mind made up yet on this. I do think I need to do a lot of thinking on this, but to me, there's a lot in here that I think we need to consider and talk about.
Sure, and I'd certainly encourage you. I candidly don't know who replaced Paul Foster when he retired from code enforcement, but I'd certainly encourage you to talk to the director of code enforcement in the county and find out what is the current number in the ordinance for unrelated individuals and what actions they're literally taking on it. Because whether you live in a city or county, it doesn't make a difference. The laws are there and they need to be handled to protect your neighbors. And this bill is not in any way, shape, or form trying to alter that paradigm.
Mr. Rutledge?
Thank you, Mr. Chairman. Mr. Olens, is there anything in current law that triggers a property owner to register their house with an HOA that they're renting it? How does an HOA even know? Like, Representative Reeves, 300 homes,
Well, some of the covenants require it. So for instance, I moved into a townhouse community in downtown Marietta, and I was told that there can't be more than 4 townhouses that are rented, and that if you want to rent your unit, you need to be on a waiting list. So it's generally within the covenants as compared to any statutory type law in that regard. The problem, of course, comes from the 2018 decision that I mentioned. But associations do have the, when you do your annual dues, they have the right to ask questions, et cetera. So
Okay.
I think there is the ability.
And would most of those that already have that in there fall under this? I mean, if it's, I would think that those associations would be, this would apply to those.
So for
sure.
instance, when our developer put together the covenants, they put in the fact that you could have 4. Many of them have 0. And once again, that's not the homeowners, that's not the board making the decision. It's the developer who created the subdivision that's making that decision.
Thank you.
Thank you.
I think that's all the questions.
I would comment if possible,
Sure.
just Chairman, I would simply say this, of course, this was initiated in the Senate. As Senator Ligon is familiar, there was a negotiation between numerous groups before the passage occurred in the Senate. So I don't want members of the House committee to think that this just was introduced in the Senate and what was introduced is in front of you. There was a negotiation between an interested group and our group, a shaking of hands, and that then went to the floor of the Senate.
Ms. Oliver, you had a question?
understand
Hold on
that.
1 second, Ms. Oliver. Now try.
I understood there was prior negotiation. I think the issue for me and maybe others is the party house. The party house is a big complaint in my area too. If you have no objection to the amendment and we can define the time, then wasn't that brought up in the Senate? Didn't y'all discuss party houses in the Senate?
No.
Airbnb issues in the Senate.
Senator Ligon, yes, let me let you address it. Hold on,
I just thought he's the better person to
let's
speak.
see, that would be let's try number 11.
I just want to know if that was rejected. In the
Yeah,
Senate.
let's let Senator Ligon address that.
No, it was not rejected. It was really not at the forefront of our discussion. Everything was more around the context of the language of the bill that you have here and coming to the consensus and the agreement on what you're looking at. And the short term, really, it was not.
Well, if I understand Representative Welch's amendment, it seems to me that the homeowners associations would still be able to regulate what you're talking about.
Which is what I.
It's a long-term rental that
Right.
that this would have a grandfathering effect, if I understand
And
it correctly.
the only other short-term rental that is controversial in my neighborhood is the movie industry renting a house, which causes.
Understood.
I mean, I thought it was entertaining that they were filming a movie. With
The first
cable.
time it probably is.
Right. Exactly.
Yeah.
But we share your concern about the
So
party
it's just
houses.
the timing of 6 months is good with me, but I'm surprised there wasn't discussion about this previously.
Okay. All right.
Thank you very much, Chairman.
Mr. Owens, why don't you take a seat in the back of the room back there behind Representative Dreyer? Because if more legal questions pop up as we go through this, I want the committee to have the ability to ask you questions.
Thank you.
Do you got something? Okay. All right. There you go. All right. We have at least one other witness that is signed up. The chair would call to the area outside the Judiciary Committee, Lanier Coulter. Lanier Coulter. Let the bailiff sound. Mr. Coulter, welcome. Good to have you with us today. We'd be happy to hear from you. I would let you know that because you're about to address us, the speaker has said to us this morning, anybody using the microphone to address, you can take your mask off. So um, welcome. Please introduce yourself. Tell us who you are and who you're with, and we'd be happy to hear from you.
Thank you. Thank you all for your time today. My name is Lanier Coulter. I am the chairman of the Community Association Institute's Legislative Action Committee. So I've been down here a few times in the past to talk to you guys. Happy to be here today. We met outside the Senate Judiciary.
Real quick, though, before
Sorry.
we get started, make sure we all understand who your group is. and
Oh,
what
I'm
they
sorry.
do. Yeah.
Absolutely. Sorry, Mr. Chairman. So our group represents the attorneys, the management companies, the homeowners associations throughout the whole state of Georgia. We've certainly heard from them on this legislation and the amount of time that we've had between the Senate and today.
And your position with them is?
I'm the chairman of that committee that
Chairman.
communicates with all the different attorneys,
Okay.
management companies, and
Are you an
HOAs.
attorney?
I am a practicing attorney at a
God bless you.
community association firm. That's all I do day in and day out is represent community associations. So I'm pretty familiar with the issue that we're going to be talking about today.
So you know when we ask you questions now, we expect even better answers. So.
I'm a lawyer, so I have answers.
Okay, all right. We're happy to hear from you.
So thank you. So we met outside the Senate. This bill kind of came pretty fast, and we agreed in good faith to negotiate on the House side about this, get it out of the Senate and negotiate. Then a lot of life happened, and that was 3 months ago, give or take. We did propose some changes to this, and I'm happy to talk about case law. I'm happy to talk about the Georgia Property Owners Association Act. But if you don't mind, I want to take a minute and kind of talk about, if we're going to work in good faith, some changes that we thought the bill should have to try to find that balance.
And may I ask one question of you there also? Were you able to hear the two proposed amendments that Representative Welch had mentioned earlier, possibly?
I was.
Okay, so you can
Absolutely.
incorporate those into our discussion. Good.
But two of those, both were on my list of 4. So,
Okay, good. All
so,
right.
but the first one was the prohibiting or restricting any lot from continuing to be leased or rented pursuant to the original instrument upon conveyance or transfer of title to such lot to any successor in title. And I believe your proposed amendment, one of the things was to bring an end to this grandfathering as soon as it's conveyed to someone else. We also, in our proposed amendment, we're going to say restricted new leases for any lot with respect to a new tenant from being a term that is less than 1 year to deal with the Airbnb. I understand your proposed amendment was 6 months. We found in the practice area, normally we do an amendment, and there's nothing wrong with the 6 months, but we normally, when we amend to restrict leasing, say the initial term should be 1 year because it helps alleviate that short-term rental issue that comes up. We see in my world a lot of legal effort to put it into entities, trust, workarounds, and those things take time to dissect and realize they're trying to do an end round of a leasing amendment. And an initial term of 1 year gives us plenty of time to work through those issues, logistics, and enforcement. And speaking of enforcement, the party house that I heard mentioned a few times in here and everything else, our proposed amendment would also provide for the enforcement of sanctions in an amendment, even against that grandfathered owner, consistent with everybody else. And those enforcement actions that we're proposing would run the full gambit if the amendment provides for it. Fining, suspension of rights, even termination of the lease. That's a pretty standard leasing amendment in Georgia today. And the fourth one, before I circle into the academic discussion of the case law and everything else, we also propose an amendment that would provide that any lot that is grandfathered has to continue to be leased. It can't have a 90-day break of leasing or it can lose that grandfather status. Abandoned homes exist even in investor-owned properties, and they create problems for our communities. Even investor owners don't put a lease in place for months at a time on occasion. Most of the time they're in it to make money, so they want tenants constantly.
On line 27 of the bill, when it says the word continuing, what effect does that have on what you were just asking us?
No amendment shall be made to the instrument so as to prohibit or restrict a non-owner occupied lot from continuing to be leased or rented pursuant to the pre-amended instrument. There would be nothing binding after an amendment on that. They're exempt from that amendment. So they could take the position, I'm an investor owner, I can continue to lease. Nothing changes for me, whether my current tenant moves out, whether a new tenant moves in. There's no clarity in that as to what exactly it means. It can continue to be leased or rented. So there's no, does that expire when the tenant moves out? Are they bound by other changes in the documents once that tenant moves out? There's no clarity there.
Go ahead and continue.
So, and again, this is our effort to work in good faith to find that balance. But I just want to point out, Georgia law has consistently allowed people to buy into communities. You don't have to buy into a coveted community. It's a choice. But when you buy into it, you take title subject to those covenants, and you're charged with notice of everything in there, including the right to amend and change those covenants. That's a common known risk in buying into a coveted community. That's not something that's hidden from anybody. Amendments have been argued about, litigated since the 90s. So in order for a leasing amendment to even take effect in Georgia, the first step for most communities is to submit to the Georgia Property Owners Association Act. That decision alone puts them in a trigger where it takes a super majority to change any burden running with the land. We focused on leasing, but if we wanted to prohibit pit bulls, once you submit to the POA Act, which is step one, it takes a super majority. And so I don't want to downplay that 1/3 or less of the people may have their rights changed, but they bought into a community knowing that. And a super majority spoke that this is in the best interest of our community to amend and put these restrictions in place. And I think, just so we're all on the same page, I've been doing this 19 years, this practice area. I have colleagues that have been doing it longer. I've spoken to my colleagues. I practice here in the Atlanta area. We do grandfathering in every amendment because the most likely person to sue you is going to be an investor owner that you say you have to evict your tenant next month. In 20 years almost, I have not seen an amendment that says that, and I advise my clients, you could be sued and lose because you are taking away a right. Our amendments grandfather them already until they convey title. So we want to work in good faith on legislation for everybody, but more often than not, we're just not seeing this issue of a investor owner suddenly losing their rights. The law has, to pass a leasing amendment with a super majority vote, 2/3 plus, is a huge hurdle in community associations. If you live in them, usually they don't even get quorum at their annual meeting. So to set a benchmark at 2/3 of everybody is a high hurdle. One other thing I just want to point out, because when we started all this discussion way back in the Senate, the example was a long-term, high-end neighborhood situation. Most of our leasing amendments are actually in communities where people, for the first time, bought a home. Maybe even a step up from that, a little bit nicer neighborhood. These aren't million-dollar neighborhoods. Most of our leasing amendments are in communities at a totally different price point where that homeowner was excited to buy in and suddenly finds out an entity bought 5 homes, 6, 7, and they want to talk about how they put a cap in place, not ban leasing, not take away their right. How do we stop it so we don't hit 40, 50% rental in our neighborhood? And that's where these amendments typically come from.
Questions? Okay, thank you. Well, Mr. Whip, hold on one second, Mr. Whip. Go ahead, Representative Kelly.
Thank you, Mr. Chairman. And this kind of goes, I think, what you spoke about a minute ago, where you said you could sell an investor on property that's abandoned. What do you consider a time period would be between when one lease expires and the next lease begins? Me and my wife are casual property renters. We casual landlords, and I had a lady move out at the 1st of June. I've been tied up with an election and now in the legislature, and it's probably gonna be 6 weeks before I get it back able to at least mark it again. So it may be 2 or 3 months before I get another tenant in there. What do you think the turnaround should be?
Our proposed language was 90 days.
Okay.
Abandoned for 90 days. And that would mean you have no lease in effect for 90 days. If you get a lease in that window of time, we're not overly concerned with whether your tenant is living there. You have a binding lease agreement. That's how the language is drafted. Excuse me, our proposed language.
We normally encourage the parties to work together because the parties obviously are experts, so to speak, in the areas in which they have interest. And then when they can come together on agreements, it helps us. And when we're judge and jury on these things, so to speak. Now, this bill passed out of the Senate 3 months ago. Have you reached out to the other side since then?
So I believe it passed out on the eve of COVID-19, but on March 12th, yes, we put our proposed changes out through lobbyists. And then our lobbyists, once we found out Friday, we were put on today's calendar, reached out again on those matters. And we're still happy to talk to them.
Did you call anybody?
Our lobbyist did. Sorry,
Who is that?
Rob
Fortson.
Fortson.
Okay.
Yes.
Understood.
From McGuire Woods.
All right. Okay.
We had Ashley Groom in the past doing it as well back in March.
Understood. Okay.
Yeah.
All righty. Well, look, we appreciate you being here today. I do have one more witness I want to sound for, and that is, and what we will do is there's an empty chair right behind Senator Ligon. Since we have space in the room and the members may have questions, we'll let you stay, Mr. Lanier. We appreciate you, Mr. Coulter. We appreciate you being here today. And if you'll sit right behind him, Mr. Tony, if you're in the hall, you certainly are welcome to come in and we'd be happy to hear from you. As is always the case, I know that Mr. Tony was asking about being here, but he did mention he had somewhere else he had to be also. He may or may not be still there. You didn't see him out there? Okay. We'll let Evan come back in. All right. Assuming he is not there, Senator Ligon, do you have any final comments you wanted to give to the committee, or do you want either one of your witnesses you brought with you to make any comments? I don't mind if both of you do, but you can sit. You can hold on. Let's just sit right there. I assume that Mr. Tony was not out there. Try now.
Thank you, Mr. Chairman. I think the concerns that were addressed with the 6 month or 1 year term, as well as the language after the sale of the lot, keep in what the intent, I think, of what this bill is intending to do. We'd be supportive of that amendment.
Okay. You mean Representative Welch's amendments?
I'm sorry.
Representative Welch's amendments, both of them?
I'm sorry.
Okay. I'm sorry? Oh, yeah. The masked man in the corner. Okay. All righty. Senator Ligon, anything else? 1 second, Senator. Try now.
Okay. I think you can hear me now. And I just, again, we have no objections to Representative Welch's amendments. I think they're good amendments. I would just hate to see you put in time limits on vacancies. You could have situations where renovations are being made to a home and it could take 30, 60 days and then another 30, 60 days to market it and rent it out. I think that starts hitting in on the concerns for investments that are made. So we would just ask the committee to just look at Representative Welch's amendments. I think they address most of the concerns that have been raised.
Representative Reeves?
And Mr. Chairman, if there's any further discussion, then I certainly don't want to stop that from happening right now. But I think the best thing to do at this moment, or at least this is how I feel. I know we have a very short period of time for legislation to move, but I would like to see this committee hold this bill today. I feel like I need to have some conversations and I need to dig a little bit deeper into this. I'm not ready to vote one way or the other today. And I think that if we held this today and had some conversations, then we can better explore and consider the potential amendments. And so I think that it would be, again, I recognize the challenges we have with the timing, but I also anticipate that your committee will probably meet again. And we have a lot of time to talk in between votes, as we learned today on the House floor. So we could write a lot of legislation in that time it takes to vote. But my request to the chairman is to just hold this bill today.
Let me ask Mr. Reeves a question. So I don't know yet of anybody that has objected to Representative Welch's 2 amendments. And now I would gather there may be some people that want more amendments or maybe want them to go a little further, but I haven't heard any objection to those 2. What if the chair entertained a motion, we added those 2 amendments, we left the bill in that format, and then the chair suspended the hearing until maybe tomorrow to give you understanding, normally I would say several days, but given our circumstances, I would say till tomorrow, and allow the parties to talk with one another. Now, that's just what the chair is thinking about right here. I said I heard no one object or express dislike for Mr. Welch's amendments, other than recognizing some may want more. But I'd like to get the bill in a format where when we come back tomorrow, it's typed out differently, and we're working off that. What are your thoughts about that, Mr.
Yeah, I don't have any objection to that.
Okay. Well, I'll tell you what the chair is going to do at this time then. The chair will accept a motion to put this, hopefully to put this into a format where we could talk about the 2. Mr. Whip, did you want to say something before the chair does that?
Just to continue with that, I think that what you're asking for is first the motion do pass. And so I would make that motion.
There's a motion do pass by the whip. There's a second by Ms. Oliver. Now we're in the position for potential amendments. Representative Welch, you want to state your 2 amendments again?
So I will. Chairman, I have 2 amendments. They're just going to be slightly different than what I read before based on some testimony that I heard. At line 27, between the word rented and pursuant, insert the language an initial term of 6 months or longer.
An initial term of 6 months or longer. So what'd you change?
I added an initial.
An initial. Okay.
Yes, sir.
Mr. Myers, you got that? Hold on 1 second. Julius, you got that? Give me the thumbs up is all I need. He's thumbs up. All right. There's a motion by Mr. Welch and a second by Mrs. Oliver. Is there objection? If anybody on Zoom has an objection, you can give me a thumbs down. I see none. That amendment is accepted. Mr. Welch, you want to talk about your second one?
The second amendment at line 21, Mr. Chairman, is between the
Line
word,
28, rather.
Sorry, 28, yes.
Mhm.
Line 28, between the word instrument and the period, to insert a semicolon followed by the language provided, however, comma, that upon the sale of such lot shall be made to conform to the instrument as amended.
We decided to leave it at instrument after some discussion. It was better.
So it would say semicolon provided, however, comma, that upon the sale of such lot, upon the sale, it should be upon the sale, such lot shall be made to conform to the instrument as amended.
Mr. Whip, you had questions?
No.
You okay? Yeah, I'm just. Mr. Talbot, did you get that? Thumbs up? Thank you, sir. All right. There has been a motion. Is there a second? Ms. Oliver seconds it. Is there any objection to that amendment? It's in. Now, what I would like for us to do, Mr. Toller, if you would make those changes for us and get back to us a draft with those two changes, that is what this committee will consider tomorrow. So at this time, the chair is going to suspend the hearing and give the parties the ability to talk about possibly further amendments besides the two that are already there. But I think at least those two will allow us to move the ball down the field a little bit, and then we'll have the committee's will on where we go from there. Committee members, I want to thank you for helping the chair work through this initial meeting, and everybody that joined us by Zoom as well. We will continue to try to make this work better for all those involved. The only difficulty really with the Zoom process is that the chair has to turn off everybody else's mic in order to hear them, and that can be a tad cumbersome, but we'll certainly try to work our way through it. So right now, it is the chair's intention tomorrow to have another Judiciary Committee meeting and have it 15 minutes upon adjournment of the House. The chair's idea is, while we can do it, if you're here, I'd rather just you be able to stay here rather than us saying two and you want to leave and then have to come back. It's always an inconvenience, even more so now maybe than normal. So there probably will be a notice. It probably will say this bill, possibly some others. I will tell you that Representative Welch has a bill that we will send out the draft of it, but he has been speaking with various members of the judiciary around the state. He is trying to assist us to get the court system open back up, and there has been some consideration of a possible 6-person jury allowance when in a criminal matter agreed upon by the parties and when in a civil matter ordered by the judge. You've been floating that with the various groups that would be interested in that, and I wanted to give you all a tad preview to that so you could be thinking that through in your mind, but it would have a 1-year life to it to allow us to get through this process. And I didn't really want to go into more than that unless you feel a real need to say something. Do you? Okay. Just want to give you a preview for what we might sub a bill out tomorrow that's not being used to let us do it. Yeah, absolutely. And we'll be getting out the exact language in a notice to you. That also, as well as possibly others, could be on the agenda for tomorrow. So having said that, thank you all for being here today, and we will stand adjourned.